Welcome to our August 2023 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's Payroll Advisory Practice. In this edition of This Month in Payroll, we will explore a significant decision in which a company director has been found liable for wage underpayments, the ATO's enhanced focus on superannuation guarantee compliance, and a look at the key regulators' FY23 performance scorecards. We'll start with a Federal Circuit and Family Court decision that considered the accessorial liability provision of the Fair Work Act. This provision has the effect of holding a person involved in a contravention of the Fair Work Act equally accountable as a person who commits the actual contravention. The case of the Fair Work Ombudsman against Chartime Australia Proprietary Limited No. 2 involved the bubble tea chain, Chartime, which failed to pay a range of minimum entitlements under the Fast Food Award, totalling $162,000 for approximately 150 employees across a 4-month period in 2016. These failures covered a range of entitlements, including minimum hourly rates, casual evening, weekend and annual leave loadings, public holiday penalty rates, overtime and minimum engagement. Back in 2013, Chartime wasn't paying its employees with reference to any particular award, and the Chief Financial Officer at the time sought legal advice that concluded its employees were covered by the Fast Food Award. On the basis of this legal advice, the then CFO calculated the rates he considered were applicable under that award and developed 2 alternative costing models, one in full compliance with award obligations and the other in partial compliance only. These models, together with a comparison to the actual rates being paid at the time, were presented to the co-founders, including the respondent, Mr. Chen Zhao, and 2 other employees of Chartime. The CFO's analysis concluded that there'd be an incremental cost of about $855,000 per annum for Chartime to achieve full compliance with the Fast Food Award, or an additional cost of about $254,000 to achieve partial compliance only. A decision was made to implement the option achieving partial compliance only, which included correct minimum award rates and a uniform allowance, but did not include other loading and penalty entitlements. In his defence, Mr. Zhao argued that he did not understand or fully appreciate exactly what an award was, or the ramifications for non-compliance with an award, and he denied that he was involved in the development of the costing analysis. In reaching its decision, the court considered whether Mr. Zhao, being the alleged accessory, had actual knowledge that the award applied to the relevant employees, that the work of each of the employees gave rise to the specific entitlements of that award, and that they were not paid those entitlements. The court ultimately concluded that when he approved the approach to paying partial award entitlements only, Mr. Zhao did not believe he was implementing a scheme that was unlawful. Regardless, Mr. Zhao did acquire sufficient knowledge of the entitlements in the Fast Food Award to understand the differences between the payment approaches, to assess their relative merits, and to ultimately be considered complicit in committing Chartime to not pay employees all of their award entitlements. The directions on penalties will take place on the 31st of August, after which we will know the personal consequences for Mr. Zhao. This decision is a reminder of the obligations and potential exposure for individuals who can be held personally liable under these accessorial liability provisions. If found to have been involved in a contravention, an individual's personal liability can extend to the underpaid wages and entitlements, as well as penalties. This provision doesn't require that the person knows their actions are a contravention, but instead that they have actual or inferred knowledge of the subject that constitutes the contravention. Company directors, as well as HR, finance and payroll managers, can all take steps to protect themselves or minimise their exposure, including seeking timely legal advice about the award or enterprise agreement coverage and classification of employees, regularly reviewing actual payments made to employees against the entitlements of the relevant instruments, contracts and policies, fully investigating employee questions or complaints about pay and entitlements, and asking questions and seeking specialist advice if there are any concerns about pay and entitlement compliance. Now to the ATO's enhanced focus on superannuation guarantee compliance. This has been a consistent theme of late, and with the start of a new financial year, we see emerging evidence of the ATO's commitment to further strengthen its focus on superannuation and to bolster the tactics it employs to identify and address instances of non-compliance. In late July 2023, the ATO released its FY24 corporate plan. Commissioner of Taxation Chris Jordan laid out the ATO's vision that where possible, through smart use of data and digitalisation, tax, superannuation and registry interactions just happen. The corporate plan identifies 8 key focus areas for the year ahead, one of which is improving superannuation guarantee integrity, and another being the use of differentiated strategies and targeted interventions to address collectible debt. With continuing investments to further advance the use of data and digitisation, the corporate plan includes specific commitments to progress development of transparent and consolidated SG compliance information that will allow the ATO to proactively follow up employers' non-compliance. Improve communication to support employers to self-correct SG issues and keep up to date with their obligations. Continue to focus on employer and superannuation fund reporting timeliness, completeness and accuracy. And include new measurements of SG charge raised, collected and distributed in the ATO's annual report. The plan was released at a similar time that ATO Deputy Commissioner Marek Wroczynski provided insight at a Government Services Summit into the ATO's use of artificial intelligence and deep learning models to identify some $300 million in superannuation guarantee underpayments. The Deputy Commissioner confirmed that the ATO is already using these advanced methods to mine large data sets and identify anomalies for targeted investigation. You might also recall that as part of the FY24 federal budget, the government set targets in the Treasury portfolio for the recovery of unpaid superannuation. The ATO's enhanced targets on the recovery of unpaid super, coupled with the strategic objectives and investments in enhanced technological solutions, will all contribute to a laser focus on super compliance. Employers should prioritise regular, proactive reviews to satisfy themselves that their processes, systems and detective controls enable them to meet all superannuation obligations. Finally, the close of the 2023 financial year triggered a number of announcements relating to the performance of regulators across FY23 and indicators as to their likely priorities for the year ahead. First, to the Fair Work Ombudsman. The acting Fair Work Ombudsman, Kristen Hanna, announced that the FWO recovered $509 million in unpaid entitlements for some 250,000 workers across FY23. She noted that over 60% of those recoveries relate to the large corporate and university sectors, with the majority of these matters being self-reported. The FWO also continued to invest in its education and advice and observed a 19% increase in traffic to its website and a 13% increase in use of the pay and conditions tool. Very pointed observations were made about the university sector in particular, but those arguably have equal application to other sectors. The acting Ombudsman noted that, in addition to a lack in payroll investment, the FWO has observed poor governance and oversight, a lack of centralised systems and processes across faculties, and control over human resources and pay being dealt with by academic managers rather than HR and payroll specialists. And after a busy year implementing the Secure Jobs Better Pay changes, the Fair Work Commission President, Justice Hatcher, reflected on the Commission's performance across FY23. He observed that the Commission had met or exceeded its portfolio budget statement key performance indicators, including a clearance rate of 102% across approximately 32,000 lodgements. The Commission also reported the expedited approval of enterprise agreements, with 50% approved within 3 weeks and 90% approved within 6 weeks. Now to the Wage Inspectorate of Victoria. Since it assumed responsibility for regulation of Victoria's wage theft laws and long service leave obligations in 2021, the Wage Inspectorate of Victoria has a number of high-profile matters with ongoing litigation before the courts involving Optus, ComSec and Bankwest, amongst others. In early August, the Inspectorate added Woolworths Group to this list, commencing proceedings in the Magistrates Court of Victoria, alleging a failure to pay Victorian long service leave entitlements totalling over $1 million to some 1,200 former employees. Reflecting on its second full year in existence, the Inspectorate announced the recovery of more than $1 million of long service leave entitlements across FY23, and the assessment of more than 600 reports of alleged criminal wage theft. As it continues to develop more educative content, the Inspectorate recognised a 49% increase in website traffic to its educational tools and resources. The new Fair Work Ombudsman, Ms Anna Booth, assumes her position on 1 September, after which the Fair Work Ombudsman's priorities for the year ahead will likely be communicated. But what is already clear is a consistent focus across the various regulators to invest in targeted and data-driven investigations, and to apply rigour and hold employers to account in respect of all workplace law obligations. And that's it for this month in Payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in Payroll.